Good afternoon, everyone. We are now resuming the 5th Oxford Arbitration Day. I am Ana Carolina Dall'Agnol, one of the co-organizers of the event. It is a great pleasure to have you here. And we are now kicking off the afternoon sessions, but not before we thank our sponsors and our supporters for making this event possible. Thank you very much for your support. This is panel 3, which will address arbitration and failure to perform due to the pandemics. And now I'm connecting with Guilherme Recena Costa, who will be the moderator of this session. He is part of the International Dispute Resolution Group of Debevoise and Plimpton, and he specializes in commercial and investment arbitration. Guilherme, thank you very much for being here.
Thank you so much, Ana Carolina. Can everybody hear me? Just see me and hear me. My experience shows that that's the question one should ask when doing these things. But thank you so much. It is a real great pleasure to be moderating our next panel. We have a really unique and a high caliber lineup. First off, we have Isabelle Michou of Quinn, Emanuel in Paris. She handles not only complex commercial and investment arbitration, but also litigation in the French courts. And she's dual qualified as both a French advocate and an English solicitor. We have Catarina Monteiro Pires, a partner at Morais Leitão in Lisbon. She currently works chiefly as an arbitrator and a legal expert with a special focus on Lusophone jurisdictions, and she teaches at the University of Lisbon both international commercial law and the law of obligations. And to wrap up, we have Naomi Bearcliffe, who's counsel with Allen and Overy in London. She too has extensive experience of both investment and commercial arbitration, and she does a lot of public international law too. So our panelists today are going to talk about COVID and non-performance of contractual obligations. But let me just preface that with some very brief introductory remarks. The global pandemic, as we know, is pretty much unlike anything in our recent memory, as are the disruptions it has caused to supply chains, to all sorts of things in our lives. Having really sort of turned our lives upside down, it has thrown into stark relief how contracting parties' assumptions as to future states of the world can fail, and can fail quite dramatically, actually. And that, of course, calls into question the obligations that are entered into on the basis of those assumptions. But before we get carried away with non-performance, it's perhaps just worth remembering very quickly that obligations imposed by contract are in principle absolute. And despite their differences, most legal systems seek to enforce the party's bargain either through an award of damages or specific performance. In some quite memorable wording of the Seventh Circuit here in the US, a deal's a deal. And as I think our panel is going to show today, excusing performance is still rather exceptional. And that, in fact, makes it all the more important to understand the various manners in which the law softens the harshness of the absolute contractual nature of obligations. And that ranges from the many ways in which the parties themselves can choose to qualify obligations to a host of fairness and sort of equity-based doctrines that can apply, depending on the legal system, either through choice of the parties or as default provisions. And so while most of those doctrines are actually fairly well established, and I guess one of the overarching questions for us today is whether the contract issues that COVID poses are really novel in one way or not. The fact is that across legal systems, they are many and they are varied. So the list is pretty extensive across jurisdictions. We have impossibility, impracticability, frustration, force majeure, hardship, imprévision, excessiva onerosidade, and so on. And moreover, even within any one jurisdiction, it's possible that the application of such doctrines might actually vary depending on whether you're in court or before an arbitral tribunal. So there's both a lot of commonality of purpose, but also divergence of means that we can explore with our panel today. And it's precisely that approach that we have chosen to take, really. Because of the very richly diverse legal background of our panelists, what we've decided to do is talk about 3 topics that we think will showcase some differences across legal systems, including how COVID-related disputes are playing out in various jurisdictions, and as a result, what parties who are engaged in international commerce and transactions should be aware of. The first topic we're going to talk about is force majeure, whether as a statutory legal doctrine, as it's recognized in most civil law jurisdictions, or the somewhat sort of loose term that's used under English law and other common law systems to simply designate a class of contractual provisions for risk allocation. Secondly, we're going to talk about material adverse change or material adverse effect clauses, MAC clauses, whether in the context of M&A transactions as a condition of closing, or acceleration clauses, say in financing arrangements. And lastly, we're going to talk about hardship doctrines more generally, which of course can take a lot of forms in various civil law jurisdictions, have somewhat of a lesser role in the common law tradition, but there is the somewhat analogous English law concept of frustration. And for those of us who practice in the US, there's the doctrine of impracticability. So to make the most of that, the way we've decided to conduct our panel is a roundtable format. And because of that, we would like to encourage everybody in the audience to participate very actively, and not just at the end, but throughout, by submitting questions really in real time. And as your moderator for today, I will do my absolute best to interject with those questions as appropriately as I can to our panelists. One just final note on procedure is that we're going to try to engage in as candid a debate as possible. But of course, the views and opinions of our panelists are, views and opinions in this sort of academic setting, and they don't necessarily reflect any personal views or views of their law firms. With that disclaimer, and having already spoken a little bit too much, without further ado, I would like to ask Isabelle Michou to kick us off with some thoughts on force majeure.
Yes, thank you very much. And I was just trying to get some technical issues fixed, but I'm not sure that is done. Can you hear me well now?
I can hear you quite well. Yes.
Okay. Thank you. So first, I was asking to talk about force majeure and differential. So I should probably give you 2 key points by way of introduction. First, I'm not going to talk about French law only applicable to France. What you should know is that the French law that I'm going to talk about extends to other jurisdictions where the legal system is based on the French Code Napoleon. This is the case of North Africa countries such as Algeria, Egypt, Libya, Morocco, Tunisia. That's also the case for Francophone sub-Saharan African countries such as RDC, Senegal, Cameroon, Mali, and many others. They are based on French law, and of course, sometimes you've got also a combination with Sharia law and Ohada law, but those legal systems are based on the French Code Napoleon. So that's the first point by way of introduction. The second one is that in France, until recently, the legal definition and the conditions of force majeure were based on case law. In 2016, there was a major reform of contract law, and the definition and the conditions of force majeure were incorporated into the civil code. And I should start with the legal definition, which is now incorporated in the civil code, which is Article 12:18. And the definition goes like this. In a contract, force majeure occurs when, first, an event beyond the control of the debtor, 2, that could not have been reasonably foreseen at the time of the conclusion of the contract, and 3, whose effects could not have been avoided by taking appropriate measures, prevents performance of the debtor's obligation. That's the definition which is now incorporated into Article 1218 of the Civil Code. And that was pretty much the same thing in the case law before 2016. That definition is not of mandatory nature. That means two things. First, the parties can deviate from this legal definition in their contract, and two, they can even exclude a force majeure from their contract. That's the first thing about the legal definition. So if we look at the specific features under French law, and that would be most likely the same in the other jurisdictions that I mentioned earlier. The first is, for a force majeure to occur, you need an event which is beyond the control of the party invoking the force majeure. Very often, if you have a clause of force majeure in your contract, you will probably have a list of events that would qualify as force majeure. Very often, it's not limited. It's only a list of some events that can qualify as force majeure, but it's not a limited list. The second feature is that that event, in order to qualify as force majeure, could not have been reasonably foreseen at the time of the conclusion of the contract. And that is important because, of course, any court or arbitral tribunal applying French law or something which is based on French law would assess that by looking at the party's background at the time of the conclusion of the contract, by looking at the party's expertise at the time of the conclusion of the contract, and then the event itself would be looked at as what was considered as not reasonably foreseeable or foreseen at the time of the conclusion of the contract. The third feature of force majeure is that the event must render performance of the contract impossible. And that is important because if performance of the contract is possible, but simply more difficult or more onerous, then that's not force majeure. It is arguably something else, and we'll talk about this a bit later. It could be hardship or something else. So the standard is very high. It must be impossible to perform the contract. And then the event could not have been avoided by taking appropriate measures. That is another point that needs to be taken into account. Because, of course, if the debtor was able to find an alternative supplier, then the force majeure would not be characterized in these specific circumstances. And again, a court or an arbitral tribunal would look at what the competition did. For instance, were the competitors able to perform the contract? So those are the specific features of force majeure under French law. Now, what I should say is also the effects of force majeure once you have an event that would qualify as force majeure. And here the effects can be either temporary, and if that is the case, then the performance of the contract will only be suspended. And of course, if the force majeure goes on longer, then at some point there may be a right to terminate the contract. But if the force majeure is permanent from day one, then that gives right automatically to a right to terminate the contract. And the automatically is quite important because that is really by operation of the law. I think I will stop here about the legal definition of and conditions or specific features of force majeure under French law, and we may come back to those particular definition and features later on if there are any questions on this.
That's great, thank you, Isabelle. Catarina, can you tell us a little bit how Portuguese and other Lusophone jurisdictions, how Portugal and other Lusophone jurisdictions might differ from this French sort of background that Isabelle has presented to us?
First of all, I would like to thank the organization for the invitation and to congratulate André, Felipe, Anne, and João for this year's edition of the Oxford Arbitration Day. And it is also an honor to share this panel with Guy, with Naomi, and with Isabelle. Thank you all for this opportunity. My first word is to say that we are here to discuss very complex matters. We all know that in long-term contracts, particularly in construction and industrial contracts, failure to perform is often triggered by multiple causes. And at the same time, the world is still struggling with millions of COVID-19 cases, and Europe is facing a new round of shutdowns. And we, as arbitrators, as lawyers, and as legal experts, are dealing with new cases and sometimes with old cases requiring new answers. We have to be able to think on our feet. So what can we do? I think that comparative law is a very important tool to cope with new challenges. And if we accept this, to understand the problems related to force majeure in civil law jurisdictions other than the French law, we have to step back and to try to draw some distinctions. And the first one concerns the difference between jurisdictions that follow the German tradition and other jurisdictions that do not follow such tradition. If we look at the Lusophone world, Portugal, Angola, and Mozambique, influenced by the German model, have civil codes setting for general and extensive regulation about impossibility to perform. And the reason is quite simple. In these countries, the creditors prefer remedy against breach of contract is primary performance, that is to say, performance in specie of the contractual obligation. And therefore, impossibility to perform, which suspends or excludes claims for performance, is conceived as the most important limit on performance. And the same applies, of course, to supervenient illegality. Well, in these jurisdictions, there is no specific legal provision providing a definition of force majeure, nor setting a procedure to be followed, nor even referring to time limits to be observed. Force majeure is regarded as a mere type of impossibility to perform, a temporary impossibility not attributable to the parties. The consequences of temporary impossibility are also clear in those systems. On the one hand, suspension of performance. On the other hand, suspension of counter-performance. And this is the starting point. Nevertheless, in several civil law jurisdictions, the parties' contractual duties are not strict, and therefore, lack of fault can also be used as an excuse, and in this context, force majeure can also be seen as an exemption of liability. I have been using the term temporary impossibility, but we should note that in case of lease agreements, lockdown may be a cause of partial impossibility, causing the reduction of performance and the reduction of counter-performance. And this qualification, the qualification of a partial impossibility, derives from the nature of the agreement itself, implying units of time. I have recently read that the Court of Rome ruled on an interim relief application brought by a commercial tenant seeking to be discharged from its obligation to pay the rent. And the court decided that the tenant was entitled to a reduction of the rent, considering that the shops were closed by governmental decision. So the court decided that the landlord's obligations to provide a premise fit for the purpose, and the purpose was commercial activity, was partially impossible, and therefore the rent had to be reduced proportionally. Now, turning our attention to the other jurisdictions, to the jurisdictions that do not follow the German model, the Brazilian example immediately springs to mind. In Brazil, we find individual provisions scattered in the general and in the special part of the civil code, but we cannot find a central regime of impossibility to perform. Then there's an article, Article 393, that addresses the effects of force majeure, determining that such events exempt the debtor from liability. Well, the question now is, what about common aspects? Well, I would say that many civil law jurisdictions recognize that impossibility is only absolute impossibility in which a party cannot perform. So situations where performance becomes more difficult or less profitable are not impossibility cases. I think that this is the main view. Differently, the German Civil Code now recognizes a new doctrine of disproportion between the creditor's interests and the debtor's efforts. We do not know if this doctrine, this German doctrine that was introduced in the German Civil Code in 2001, is going to produce any impact on Lusophone or on other civil law jurisdictions. In these jurisdictions, force majeure clauses, of course, play a very different role compared to the Anglo-Saxon world. The parties cannot agree that the debtor is obliged to perform what is impossible, of course, but they can agree on the consequences of a force majeure event. The parties can take their own choices as to termination of contract, suspension of performance, and also, very important, regarding allocation of costs. In several civil law countries, a complex problem to deal with in the absence of a detailed force majeure clause concerns seriousness of the delay for the purposes of termination of contracts. When can we say that the waiting period became too long or too burdensome? The answer in many civil law countries is unclear. It is therefore advisable to include a clause in the contract addressing these issues and leaving less room for maneuver. Otherwise, courts may apply and tribunals may apply general criteria such as good faith to find an adequate solution. A final word regarding the relationship between take-or-pay clauses and force majeure also in the Lusophone world. There is a recent court decision in Brazil about the impact of a force majeure clause on a take-or-pay obligation. The court considered that lockdown of many activities could be qualified as a force majeure event affecting the purchase of energy. I'm bringing this case because I believe that similar cases may appear in the future in civil law jurisdictions. I think that's it. We can discuss these issues later on. Guilherme.
Catarina. Naomi, so we've seen a lot of sophistication around doctrinal aspects of force majeure in civil law countries, obviously because it's statutory over there. How does it play out in England?
Well, I think I could be quite brief on this, and as you alluded to in your introduction, we don't have a sort of doctrine of force majeure, and as it were, there's no freestanding concept of force majeure in English law. There's just the contract. In English law, the contract is king, the parties' bargain is king, and when we're talking about force majeure, we're talking about a specific type of clause that parties tend to include in their contracts. And what we call force majeure clauses are generally clauses which describe themselves as such, and they set out what should happen under the contract on the occasion of an event which is outside of parties' control, which may not amount to frustration of the contract, and that's a concept which we're going to come on to a bit later, but it does impact the party's ability to perform. And these clauses usually contain a non-exhaustive list of events which are considered force majeure events, and they will explain the consequences of such events. So, you know, where Isabelle was talking about how under French law, there's a sort of regime as to what happens in the event of force majeure, whether it's termination or suspension. Again, under English law, the clause is king, and it tells you what happens. And the clause may either provide for cancellation of the contract or suspension of the party's liability to perform for the period that the force majeure event endures. And then, of course, there's the intermediate, where a clause provides for suspension for X period of time, and then if that time is surpassed, then you can cancel the contract. But it will all be the regime will be set out in the clause.
Thank you. Isabelle, a fairly high-profile case in France recently dealt with these concepts. Can you just tell us a little bit more about that case and other developments in France?
Yes, that was a case involving EDF, the electricity public company, and the contract involved in that case was a contract for the purchase of electricity between EDF on the one side and Total Energy on the other side. And what happened is that basically Total Energy was to purchase electricity on that contract for a minimum of quantity every month. And when the lockdown was decided, Total Energy wrote to EDF saying, well, sorry, but based on force majeure, I cannot purchase that electricity. And I want the performance of the contract to be suspended. EDF refused, and the matter went to the French courts. In emergency proceedings, that's référé in French, and that means basically that if there is an urgency to rule on a case, then you can seize the French court in order to get a ruling as quickly as possible. So that's what Total Energy did by going to the French court, and the Commercial Court of Paris, confirmed by the Court of Appeal of Paris, decided that there was an event of force majeure in this case. And I think it is quite notable because that was the first case referring back to COVID-19 pandemic, and the force majeure was recognized. The one specific feature that I should probably mention is that in this case, there was a force majeure clause in the contract, and the force majeure clause refers back to the features that I mentioned earlier, which are in the legal definition of the civil code, but also to the reasonable economic circumstances. And it was a way of qualifying the legal definition through the reasonable economic circumstances. And it may well be the case that it is because of that reference in the clause, which was an amendment in a way, to the legal definition, it may well be the case that the French courts decided that there was force majeure as a result of the COVID-19 pandemic because of that reference, because the French courts look at the event and the specific features and determine as to whether or not those features of force majeure were satisfied in the light of the reasonable economic circumstances. And here, that was a way of giving some leeway to the French court in order to decide whether or not there was force majeure. And what was looked at is that performance of the contract has led to significant losses for Total Energy, and that's on that basis that the French court decided that there was force majeure. So it may be a specific case simply because of the clause in the contract.
That's very interesting. Naomi, English courts and French courts love to disagree. It's almost like a national sport. How do you think this case would have come down in England? Or if you can tell us other developments about how a court would look at a case like this, sort of a step-by-step analysis, I think that would be very useful.
Yeah, well, as I mentioned, it would be the English courts would construe, would take the approach of construing the clause in the contract, and as Isabelle said, in this case, for the French courts, actually, the terms of the contract were extremely important, and so perhaps the outcome in the English courts wouldn't have been vastly different. I'm not aware of any force majeure case that has come before the English courts in a COVID context yet. If a party would want to rely on a force majeure clause in the context of COVID, then it would come down to the wording of the contract. I mean, under English law, that because a force majeure clause is construed as an exceptions clause, so it provides an exception to a party's breach of contract. Therefore, it's construed restrictively. That's the sort of general rule, which would mean that, most of the time it's quite difficult to rely on these clauses. When courts look at these clauses, they take a step-by-step approach, and there's likely to be three main points that they'll consider. The first is whether the relevant event, in this case COVID, would be an FM event. Whether the event has caused interference in performance, and then have the relevant formalities under the contract been complied with. Sort of looking a bit more closely at each of those, as regards whether or not COVID would be construed as an FM event, the clause usually contains a list of events, and what you'd need to do is establish that COVID falls within that list. Sometimes in clauses one sees reference to epidemics or pandemics, then you'd have thought that it'd be relatively straightforward. But it's not super common to see that language. An act of God is something that often crops up in the list. And that's been defined in various cases before the English courts. It's usually construed as something that has such a direct and violent and sudden and irresistible, a direct, violent and sudden irresistible act of nature, such that the defendant could not, by any amount of ability, foresee what would happen, or if he could see that it would happen, he couldn't have avoided it. But the phrase has generally been construed to apply to natural disasters like floods and earthquakes. It hasn't, as far as I'm aware, been applied to in a pandemic context. It's arguable that a pandemic could be construed as a natural disaster, but I can also see an argument against it. If a clause doesn't have a list in it at all of events, it will usually refer to any events that are beyond the reasonable control of a party. It may be possible to argue that COVID falls within that kind of clause. If there's a list that has a lot of different events, but COVID doesn't look like it falls in it, but it's not exhaustive, and it has something at the end of it like and all other events which are outside the reasonable control of a party, then there's no requirement to construe the list of events as justem generis, but the list will be looked at to construe the meaning of what an event is within someone's reasonable control. So it's all a matter of construction. As I said, the next point courts will look at is really causation. Sorry, a telephone call just popped up on my screen. The court, you generally have to show that the event, the FM event, caused non-performance in the circumstances, and that the relevant party would not have performed even if the event hadn't taken place, and couldn't have taken reasonable steps to avoid or mitigate the event. As to the degree of non-performance that you have to achieve, it's generally necessary to show that as a result of the event of non-performance, performance has become physically or legally impossible, and not just difficult or unprofitable. And in that way, it's sort of where you have that absolute impossibility of performance, then the clauses reflect what I now understand is under the position under French law. So if you have a supply of goods scenario, it wouldn't be an excuse not to supply the goods just because the place where the goods are sourced has put down an embargo on export of the goods because of COVID, for example, and so it became much more expensive for you to get the goods because you had to look to another source. That wouldn't generally qualify as a force majeure scenario, but again, it will come down to the wording of the contract. So some contracts don't provide for performance having been prevented, but they just require performance to have been hindered or delayed. In those circumstances, the threshold is lower, and so there are more scenarios which would fall within the clause. And the last point I mentioned is that you have to look carefully at the formalities of the clause. Lots of force majeure clauses typically provide for notification procedures. If those notification procedures are construed as conditions to the contract, then if one doesn't follow them, then you will be precluded from relying on the force majeure clause. If they're construed as merely intermediate terms, then you should comply with them, but if you don't comply with them, you can still rely on force majeure, but you might be liable in damages if your failure to notify resulted in loss for the other party. And deciding whether or not a notification procedure is a condition or an intermediate term is a construction matter. More often than not, if a clause is very specific as to the notification procedure, has a specific time frame for notification or makes notification of the essence, then it will be construed as a condition. If it's a bit vaguer than that, then it will be looked at as an indeterminate term, an intermediate term. And so that's the general approach that the courts would go through if they're faced with a COVID situation. But as I said, I don't think the courts have considered yet any clause in a COVID situation.
Great. So one point to pick up on, one point that all three of you have mentioned, and that's really sort of at the core of this notion of the parties' assumptions having failed, is the notion of unforeseeability. Now we've gone through the first wave of COVID, and arguably there is a second wave coming up. It's already manifesting itself in some parts of the world. How does that impact, if at all, the legal analysis of these types of force majeure clauses? And maybe I'll ask Naomi and Catarina to just briefly touch upon that sequentially.
I'm going to get very boring on English law. It's going to come down to in the first instance, what the contract says. So in many clauses, force majeure clauses that you see in contracts governed by English law exclude foreseeable events. And in those cases, if a contract was entered into after the developments in Wuhan became public knowledge, then there could well be a problem for somebody seeking to rely on a force majeure clause on the basis of COVID. If a contract doesn't exclude foreseeable events, the position at English law as to whether clauses should be construed as excluding foreseeable events is uncertain. And judges have taken different views on the issue, and that could be a point which is played out in future cases. One thing is clear though, and that's assuming a foreseeable event can be a force majeure event. If the event is more foreseeable at the time the contract was concluded, then it's more likely to have been reasonable for you to have taken steps to mitigate the effect of the event. And so actually it might be that you look at it as part of a causation issue and you say, well, actually the event here hasn't caused the performance issue because this is something that could have been avoided.
Catarina, any thoughts from a civil law perspective or more generally?
Well, yes. I think that of course we are talking about contracts that that will enter into before March 2020. And I think that time and the passing of time has actually an impact on future claims. The same legal issue may have different answers depending on the date on which the problem occurred, before or after the World Health Organization declaration of March 11. And in case the affected party has to prove adequate causation between the pandemic and the impossibility to perform, I think that this is perhaps the most difficult aspect to tackle right now. I mean, I think that the issue is not that much about foreseeability, but about adequate causation. And sometimes I think that we are dealing with situations in which the impact on performance is not clear. And in some other cases, the obstacles preventing performance could have been removed, although, of course, with extra costs. And in those cases, the question is whether the civil codes in civil law countries set for a criteria regarding reasonable efforts or regarding reasonable costs. And for instance, the Portuguese, the Angolan, and the Mozambican and the Brazilian law do not expressly state that the affected party is obliged to mitigate damages and to prevent escalation of adverse effects. However, such mitigation efforts are considered to be a collateral duty imposed by good faith. What Naomi called in English law the intermediate terms, for us those are collateral duties imposed by good faith. So the major issue here concerns the measure of such efforts. And also regarding foreseeability, I think that we may find here a difference as well. In most Lusophone jurisdiction, the idea of force majeure is based upon the concept of inevitability. In Portugal, this has been confirmed by the Supreme Court of Justice. I also think that under the Unidroit principles and under the Vienna Convention on Contracts for International Sales of Goods, a party can be exempted from liability for a failure to perform if the impediment is beyond control. So the magic word is control. Regarding the problems that we might face during this second wave or after the second wave, I think that there is something that we should perhaps point out. In long-term construction contracts, the owner's claims related to delay damages are often subject to specific guarantees. And of course, that when we are talking about delays, we can have a combination of causes, delay that is imputable to the debtor, and also delays caused by COVID-19 contingencies and so on. And those delay damages are often subject to specific guarantees. And depending on the type of guarantee, this can also raise problems in future litigations. I am thinking, for instance, of interim relief to prevent enforcement of bank guarantees. There are precedents in the Lusophone world granting relief in such cases, although, of course, I cannot say that this corresponds to the dominant position, and I certainly do not purport to know whether courts are going to apply the same rule in COVID-19 related cases. But I think that will be a problem during the second wave of COVID-19 cases, which may also be a second wave of litigations. Guilherme.
Obrigado, Catarina. So we're going to move ahead a little bit now to MAC clauses, and what we'll do is we'll start off with Naomi, and then we'll kick it off to Isabelle to get an English and French law perspective on MAC clauses and what is playing out currently with that trend.
Thanks, Guy. A MAC clause, well, I thought I'd start with a bit of an introduction, just in case there are people out there who aren't so familiar with the term MAC clause. MAC stands for material adverse change, and there are also material adverse effect clauses. And these types of clauses are usually found in loan documentation, where they, I think, Guy, you alluded to this in your intro, where they amount to an event of default or a trigger for certain obligations of a borrower, or in an M&A context, in a M&A SPA, where they're intended to provide an escape route for the buyer based on any deterioration of the target company between signing and completion. So when you're talking about MAC clauses and MAE clauses in English contracts, a common banking clause will provide that an event of default will occur where there's an event which the majority of the lenders believe is reasonably likely to have a material adverse effect. And in such a context, material adverse effect might be defined as something which, in the reasonable opinion of the lenders, has a material adverse effect on the business, its operations, or financial condition, and that's, I mean, usually amongst other things. In an merger and acquisitions context, in an SPA, you might see a clause which says something like, if anything occurs except something caused by the seller, which is likely to have a material adverse effect on the financial condition, prospects, or business of the company, the purchaser may elect not to complete the purchase. So those are types of clauses we're talking about. And as ever under English law, each clause will be construed on its own particular wording. There's quite limited case law in English law on these types of clauses because they are generally construed restrictively. There's quite, with terms like material, they can be quite difficult to interpret. The burden of proof is on the party invoking the clause, and the consequences for the party invoking can be pretty drastic. So, if you wrongly invoke, a MAC clause in a banking context, then you could be held liable for repudiatory breach of the contract. So on that basis, we've had very few cases, and those cases that we have had have showed that the clauses are generally construed restrictively. However, we are starting to see some cases, MAC-based cases in the COVID context, and there was a couple of weeks ago a judgment, albeit only a preliminary issues judgment by the High Court in an M&A context on a MAC clause. The case is called Travelport versus WEX. I should say it's also currently on appeal. By way of background, WEX is a US-based company, and it had agreed to buy two entities called eNet and Optal from another company called Travelport under an English law-governed sale and purchase agreement that had been signed in January 2020. Optal's business, so one of the subjects of the acquisition, involved issuing virtual credit card account numbers that worked a little bit like physical credit cards that could be used by one business to pay and another business. Its principal client was eNet, and eNet derived the vast majority of its profits from providing business-to-business payment services to customers who operated in the travel industry, which obviously, as we all know, has been hit really hard by the pandemic. So material adverse event condition in the relevant SPA allowed WEX to pull out of the deal if any event had a material adverse effect on the business condition, financial or otherwise, or results of the operation of eNet and its subsidiaries taken as a whole, or of Optal and its subsidiaries taken as a whole. And then that clause, and this is sort of a typical where, another typical style of clauses, you usually have a material adverse event clause, and then you have carve-outs from it. So this particular clause had a carve-out for conditions resulting from pandemics. Great. But then it had another carve-out which said, except where the pandemic had a disproportionate effect on eNet and its subsidiaries taken as a whole, or on Optal and its subsidiaries also taken as a whole, as compared to other participants in the industries in which eNet, Optal, or their respective subsidiaries operate. So the key word, this was all going to come down to that second exception. Was there a disproportionate effect on eNet or Optal taken as a whole, as compared with other participants in the industries in which they were operating? So the question for the court here really was, what is industries in this sentence? And the buyer sought to argue that industries had to be construed widely, so the entire business-to-business payments industry rather than the travel payments industry. Whereas the seller argued that actually the principal, most of their money was being made in the travel industry, and there was a particular industry that related specifically to travel payments. The court agreed with WEX. It concluded that they interpreted the term as being wide, and so being the entire business-to-business payments industry, and they concluded that the pandemic had a disproportionate effect on the targets as compared to other industry participants, and therefore reliance on the MA clause was allowed. This case shows really that it does come down to the wording of the particular clause in any given case, but unusually it shows that sometimes perhaps a little bit of ambiguity in your clause might not be too problematic, because if industry had been construed in a more precise way, it might not have been construed in favour of WEX in this case. Having said that given that when people are entering into M&A deals right now, they can probably foresee that the pandemic is going to be an issue. One would generally advise a client to think very carefully about this type of clause to allow them to unwind their deal by having very specific wording.
Carve-outs from carve-outs, the feast of litigators, for sure. But let me just interject briefly before turning to Isabelle. But that's a somewhat surprising result, I think. In the US, at least, Delaware and New York courts have construed MAC clauses very, very restrictively. And it's really an uphill battle for buyers to successfully invoke them. And one of the reasons, as you say, is obviously this typical carve-out of industry-wide or market-wide events. And as far as I am aware, at least, there's no case law that's actually come out of COVID regarding invocation of MAC clauses in COVID. There's obviously some high-profile deals that either fell through or that were renegotiated by the parties, the most notable of which is probably the LVMH and Tiffany's case. But that at least tends to show, I think, that the pandemic has such a disproportionate impact on everybody generally, that at least sellers and buyers are sort of willing to come together and to negotiate solutions. And that's happened in a couple of other cases as well. Isabelle, any sort of French law or wider views on what Naomi just commented? Sorry, I at least can't hear you. I don't know if others can hear you.
Can you hear me now? Okay, good. I should say that we have seen more and more contracts governed by French law with MAC or MAE clauses in M&A and finance contracts. And that is actually a practice that comes from common law jurisdictions. But this is something that we see now quite frequently. They are not regulated by the civil code, apart from the general principles of contract law. So they will be really a matter of the parties' negotiation, and then they would be submitted to general principles such as parties must negotiate and perform their contract in good faith, and all the rules applicable to interpretation of a contract would apply, but there is nothing specifically on the MAC clauses in the civil code. And I haven't seen really a lot of case law on those clauses, and none in particular in relation to the COVID-19, but even more broadly in relation to situations of a pandemic, such as this one. I think that if we want to compare the MAC clauses with other situations, or force majeure, and what we have under French law, imprévision, something that we will talk about later, I would say that it is probably closer to the concept of imprévision or hardship, simply because we are talking about a change of circumstances that renders the performance of a contract more onerous or more difficult. But there is a key difference between the two, the MAC clauses and the hardship clauses, is that hardship clauses would primarily give rise to a renegotiation of the contract, while the MAC clauses would allow a party to get away from the deal, as Naomi just explained. So I think this is a key difference, and we'll come to that when we talk about imprévision and hardship under French law and other civil law systems. But I think that that is a key point, a key difference between the two. And again, I think that French courts would look at it, would look at a contract with a MAC clause on a case-by-case basis, really, looking more specifically at the micro situation of that particular party rather than the big picture, the social and economic big picture. So I think that that would probably be the approach of the French courts. We can't hear you.
I have two layers of muting here, just for security's sake. Catarina, can you tell us a little bit about how the incorporation of these MAC clauses into civilian law type contracts, how that has been playing out in the Lusophone world, and how that interacts, potentially displacing, or how it supplements sort of these broader concepts, including the ones to which Isabelle alluded to, like good faith and like other limits on sort of party autonomy and doctrines of that sort.
Yes, thank you again, Guilherme. Well, I think that the question we have for instance, in Brazil and in Angola and Mozambique is whether the case is or is not covered by the MAC clause, and of course to clarify this and to clarify the party's choice regarding risk allocation, we have to interpret the contracts. And as you know, this task can be quite demanding because often material adverse change clauses have a three-step structure: rule, carve out, carve right back. And this is not an easy task to perform. To interpret a contract which imports a clause from an Anglo-Saxon world, and at the same time has such a difficult structure. But if I may keep it simple, I will assume that we have a case that is not included in a material adverse change clause. And then, as you know, good faith is a traditional foundation of private law in many civil law countries. And we may ask ourselves nowadays, what is good faith? And good faith can imply many things. Can imply additional duties or collateral obligations, can imply limitations to exercise of rights, can imply limitations to waivers of rights, can imply rights to renegotiation of contracts, and eventually can imply rights to claim for modification of contracts. This is a broad scope of application that limits the parties' freedom in commercial contracts. And besides, in these countries, good faith is like a multi-purpose remedy, meaning it can be invoked as an objection to enforcement, it can be used to grant claims for damages, it can be used to correct contracts. And in some civil law countries, courts and scholars consider that the parties cannot simply exclude nor adjust remedies imposed by good faith. If we follow these steps, then material adverse change clauses cannot be regarded as an exclusive remedy to material adverse changes. In case of doubt, if the contract is not clear about the risk allocation, good faith would enable courts to police the terms of the contract. And this can have implications in post-M&A disputes, particularly when the parties have agreed on completion accounts mechanisms to determine the price. And for a long time, limits to good faith were not called into question. However, I think that if we look closer, we can observe a subtle and slow-moving trend towards private autonomy and commercial certainty in civil law countries. And we can perceive this in the recent changes to the Brazilian Civil Code introduced by the Economic Freedom Law in 2019. And if we follow this tendency towards private autonomy, we may accept that the reaction to material adverse changes is strictly limited to the terms of the clause. We may accept, as Naomi said, that the party's bargain is king. And that would be quite a revolution in civil law countries. Of course, then, that then the discussion will be concentrated on interpretation problems in which, again, good faith plays a very important role. In any case, we do not know if this trend towards private autonomy is at risk of being reversed as a reaction to the pandemic. I do not think that I am biased towards absolute freedom of choice by the parties, but I do believe that if we simply open the door to modifications of contracts without thorough analysis of the facts and of the boundaries of good faith itself, we may be creating a second layer of economic turbulence, and of course that would be a major concern, both for lawyers and of course for businessmen.
That's a very interesting point, and what I'll do is there is a question from the audience. Well, in fact, one of the organizers, Luis Monteiro, who is a good friend, he asks, and his question is directly mostly to Naomi. His question is essentially about the role of English law in the pandemic. We've seen with Catarina that perhaps the civil law world was trending towards a sort of more four corners of the page approach to these commercial transactions. But of course, as we have been talking about, and as we see in the real world, the pandemic has flipped a lot of things upside down. And so there's also sort of the converse movement of perhaps parties are really sort of unable to anticipate a lot of these events that are happening now. And some of them may feel like, when they were bargaining, they essentially couldn't foresee these events, and yet, their force majeure clauses maybe fall short, despite the best efforts of the draftsman. Do you think English law is perhaps trending in the other direction, and there's somewhat of a convergence between civil law and common law towards a balanced approach, say, or are we still sort of very much focused on the bargain is king as a principle?
I think we're still very much focused on the bargain is king as a principle. I mean, we don't have enough case law in the COVID context to show to be able to say, oh, well, English law is making a specific exception for this event, but it would be very, very unlikely. I mean, it would go against kind of all the way that English law has been developing forever. And we're going to come on, I think, to talk about the only exception to the bargain is king rule in this type of context shortly, frustration. And as we'll discuss, it's extremely restrictive, and I can't see it being broadened in a pandemic context.
Great. So now, and this seems like a perfect segue actually into our final sort of subsection for today, which is, on the one side, the hardship type doctrines that are perhaps typical to civil law system, and frustration and intractability as they arise in the common law world. Let me start off with Catarina. If you can give us a brief primer on, again, sort of just an overview of these hardship type doctrines, both in the Germanic type tradition and in other traditions that affect the Lusophone world, before we then go to Isabelle to talk about the novelish Article 1195 of the French Civil Code. So, Catarina, please.
Thank you, Guilherme. I think that you have noticed that I really like the matters that we are discussing. So I'm sorry if sometimes but I mean, I cannot. That's something I cannot help. Well, regarding hardship, I think that it is quite common to say that civil lawyers are familiar with the concept of modifying a contract. But in my opinion, it is also true that some are more familiar than others, and if the contract is silent on hardship, the question will be answered by the law governing the agreement, can bind or not with international trade usage. We have not talked about international trade usage, but this can also play important role. And again, using comparative law tools, we become aware of a clear contrast between Italian law and German law. And in Italy, the legal provision deals with cases of excessively burdensome performance. Under the Italian Civil Code, long-term contracts might be terminated if exceptional and unforeseeable events occurred during the duration of the contract, making one of the parties' performance excessively burdensome with respect to the original contractual balance. In contrast, the German Civil Code comprises a broader provision reflecting a doctrine originally developed by the courts, which is called the doctrine of the disappearance of the basis of the contracts. The German provision encompasses not only cases of hardship, but also cases of frustration, of implied assumptions, and certain cases of frustration of purpose. In civil law countries, following a broader concept of change of circumstances, the first line of cases involved supervenient disproportion between performance and counter-performance. Then the second line of cases corresponds to the situations or to certain situations of frustration of purpose. Of course, there are borderline cases of frustration of purpose, and the lines are impossibility to perform and change of circumstances. The third line of cases corresponds to, as I said before, frustration of implied assumptions. And perhaps a fourth line of cases includes, eventually a fourth line of cases includes hardship cases. And what these cases have in common is that they relate to good faith and they relate to this concept of the basis of the transaction. The unit law principles, often regarded as a useful restatement of the lex mercatoria, only refer to hardship and consider that there is hardship where the occurrence of events fundamentally alter the equilibrium of the contracts. So we have different perspectives within civil law countries, even excluding French law. Of course, I would not purport to even to say a word with Isabelle on this panel. A question that I think that we have to ask is what are the effects of hardship or of change of circumstances? And again, the consequences also differ. In Italy, the effect of excessive difficulty is termination of contracts, whereas in Germany, the affected party is also granted the right to modify the contract. And it is undeniable that the doctrine of the basis of transaction in Germany empowers courts and tribunals to correct contracts and to allocate the risks of unforeseen circumstances. In countries following the German tradition, it is debatable whether there is another of the consequences and whether the preferred consequence is modification. Also, in those countries, it is controversial whether good faith imposes a duty to renegotiate a contract before resorting to claims for modification based upon change of circumstances. These two models, the Italian model and the German model, are relevant if we consider, for instance, again, and I'm sorry about that, the Lusophone world, Portuguese, Angolan, Mozambican codes contain regulations inspired by the German doctrine, whereas Brazil follows the Italian model. And this is just about the law. And we cannot forget, of course, case law. And when it comes to court decisions, quite surprisingly, in Portugal, in Angola, and in Mozambique, court decisions tend to dismiss claims based on change of circumstances, setting the bar high. While in Brazil, courts seem to leave more room for interventions and for termination of contracts. So again, I am trying to use comparative law as a resourceful tool to handle the difficult cases and the difficult situations we will be tackling during the next month. And thank you again for your time and for. And I'm sorry for my enthusiasm when I talk about comparative law.
Your enthusiasm is what keeps us going, Catarina. Isabelle, obviously French law has a very rich history of sort of hardship doctrines, going all the way back, of course, to the State Council and administrative law. Can you tell us a little bit about what the state of the law is today and what you've seen in the context of the pandemic, including, attempts to renegotiate or rebalance contracts?
That there is a history in administrative law, in public law, because interestingly, it was not possible to have hardship in private law contracts unless you had a specific hardship clause in the contract. But that was the only exception. But now with the 2016 reform of the contract law, there is now a specific provision in the Civil Code, which is Article 1195 of the Civil Code, which creates this imprévision hardship defense, which is now available for private law contracts. And it goes like this. If a change of circumstances, which was unforeseeable at the time of the conclusion of the contract, renders performance of the contract is excessively onerous for a party who did not undertake to bear the risk, that party may ask the other party to renegotiate the contract. And the first party must continue to perform its obligations during renegotiation. So that's quite interesting because, of course, that was something which had been tried again and again in private law and successfully when there was no contract, closed hardship contract in the contract. But now this is possible. I should probably say that there are two limitations to that imprévision hardship defense, which is now in the Civil Code. The first is that it should only apply to the contracts entered into from 1st of October 2016, although here just some qualification, because there is a recent decision by the Paris Court of Appeal of January 2020, which has decided to apply that hardship defense, even though there was no clause in the contract and it was a contract entered into before the 1st of October. So we can see already that the French courts are ready to move on and apply these hardship imprévision defense, even though they are dealing with a contract entered into before the 1st of October 2016. And the second limitation is that hardship defense does not apply to some specific contracts. For instance, the sale of financial bonds or instruments. That is there is a specific exclusion there, which is in the monetary and financial code. It's not possible to include in those kind of contracts a hardship clause. Again, the hardship provisions, which are now in the civil code, are not mandatory. That means that the parties can deviate from those provisions. They can even exclude hardship if they want. That is, again, really a matter for the parties to negotiate. What I should just say by way of summary about the features of that imprévision hardship under French law is that, so you need a change of circumstances that was unforeseeable at the time of conclusion of the contract to that change renders the performance of the contract excessively onerous. And frankly, here we don't have much case law, and would suspect that it will be it will lead to some uncertainty as to how French court will apply that test, because of course by excessively onerous you could probably put quite a lot in that. So I think there will be some case law which will not be entirely settled for some time. And the third feature of the imprévision hardship defense, which is now in the civil code, is that the party relying on hardship did not contractually undertake to bear the risk of this change in circumstances. And of course, that goes back to how the parties negotiated their contract in the first place. Has to the effects of the hardship imprévision defense now in the civil code. I think that that was mentioned earlier by Catarina. The main effect of that new defense in the civil code is that the party will seek to renegotiate the contract. So it's not to get away from the contract, it's really to renegotiate the contract. And I think that here you've got two situations. One, the other side, the other party does not want to renegotiate, and that's the end of it. Two, the renegotiation takes place but fails. And in that case, the matter can go to the court. And here, what the court can do, it is more doctrine than case law, but what the court or the arbitral tribunal applying the relevant law, so French law, would be able to do either the modification of the contract or the adjustment of the contract, or terminate the contract. Those are the two possibilities that a court or an arbitral tribunal could have in case of disagreement by the parties. And of course, as I mentioned earlier, there is no case law in relation to COVID-19. But again, that's also a very new provision in the civil code. So even irrespective of the COVID-19, there is not much case law anyway.
Thank you. So for our final, I think, point, we will talk about sort of the common law view on these types of doctrines. Before turning it over to Naomi, let me just say that impracticability under US law, it's codified in the Uniform Commercial Code. It's a little bit similar to these hardship doctrines, except that it doesn't really lead to renegotiations unless you actually have a hardship clause that imposes that. But it does have some of the same elements and a little bit of the same feel. But the effects, again, will be different. Even though courts and tribunals will generally try to act in a sort of equitable manner and will treat contracts, say, as divisible contracts, which might in the end have an effect somewhat similar to a rebalancing of the bargain. But English law, I understand to be even more restrictive, perhaps, Naomi, and in particular with the doctrine of frustration. Can you tell us? I'm afraid we don't have a lot of time, but if you can sort of synthesize it very quickly, I'm sure we would all appreciate that.
Yes, absolutely. I'm just going to correct one point I made earlier. So I think I misspoke on WEX. So the case we were dealing with that dealt with material adverse effect clause, that was a preliminary judgment. And so WEX hasn't been released from its obligations yet. It was the court's interpretation of a clause as a preliminary issue. And that interpretation is now on appeal and the case has not yet been decided. So just wanted to set the record straight on that for everybody. But turning back to frustration, turning back to this discussion, as you say, we don't have this concept of hardship in English law. We have got one sort of escape route from the party's contractual bargain, but because the contract is king, it's extremely restrictive. And it will only take place where an event supervenes which is so significantly changes the nature of contractual rights or obligations from what could have been contemplated at the time a contract was entered into, such that it would be unjust to hold them to the literal sense of the stipulations. And in those circumstances, a party is discharged from performance. But as I said, it's construed very narrowly, so it can't be just that it's more onerous to perform, or even kind of greatly more onerous, or the phrase that Isabelle was talking about in French law. It certainly can't be more expensive to perform. It has to be essentially incapable of performance. So examples of the types of cases where we've seen frustration play out, or where there's been destruction by fire of the subject matter of the contract, or the subject matter of the contract is unavailable for performance. So, where an opera singer is due to sing on the first night and can't sing through due to illness, and that first night is essential to the contract, then you might have frustration. Or you have cancellation of an event where the whole purpose of the contract was to view the events. And we've got a sort of couple of cases that are relate to the coronation of, or the postponement of King Edward VII's coronation due to his illness, that are very famous for dealing with frustration. But the fact that we hark back to cases at the turn of the 20th century perhaps indicates how the doctrine hasn't really evolved and how restrictive it is. There's certainly no case law in a COVID context, but it's sure there's unlikely to be a frustrating event in and of itself, but it could give rise to frustration. For example, where there's, on the basis of illness on a huge scale, it's their insufficient staff or raw materials or transport to perform a contract. That's where you could sort of see frustration potentially playing out. A couple of just other points that may be relevant to the application of frustration in a COVID context. One is timing. If a contract is you're unable to perform a contract for a short period of time, but due to COVID, but actually the contract is due to run on for a very long period of time, then the contract's unlikely to be held to be frustrated just because it couldn't be performed for a short period. And we've seen cases from the US actually, and from Hong Kong in a sort of pandemic-like situation, which one could imagine the English courts looking to. The other point to note is that for contracts entered into after COVID was known about, it's going to be likely very difficult to argue that a contract would be frustrated, because in considering whether there's frustration under English law, courts take into account parties' knowledge at the time of the contract, when they concluded the contract, when they're considering whether frustration occurred. And the more that a subsequent event was foreseeable, or was in fact foreseen at the time of the contract, the less likely it could be regarded as frustrating, because if the parties were aware of the risk of an event, they will or should have dealt with it in their contract, and therefore the contract would be unlikely to be held to be frustrated. So as you can see, frustration is really very restrictive in English law. And there's the result of a frustration, if you get there, is that the contract's discharged, but we don't have this rebalancing concept at all.
Great, and I think under New York and American law more generally, I think that the approach is quite similar. very restrictive. Courts will construe the purpose of the contract very broadly in order to say, well, this broad purpose hasn't been frustrated. So I think that wraps up our panel. We hope this has been well, helpful, I suppose, but also sort of joyful for you. Catarina's enthusiasm certainly helped on that score. Let me just, there's one announcement that I'm supposed to make, which is, I believe, and if it's not there, it's not my fault, but I think there's a link under the video, the bottom of your screen, and that should take you to the link for the next panel, which I understand will start in about a quarter of an hour. It's been a real pleasure to moderate the panel. I want to thank our panelists again. I want to thank the organizers and the sponsors for setting up this great event, and we look forward to at some point seeing everybody in person again.
Thank you.
Thank you.
Thank you. Thank you all.